Thank you. Thank you, Chairman Eugene. My name is James Fishman. For the past 30 years, I have represented New York City tenants and consumers as an attorney in private practice. Prior to that time, I served as an assistant attorney general in the Consumer Fraud and Protection Bureau, and after that as a staff attorney at the Legal Aid Society. My private practice over the last 30 years has consisted primarily of defending residential and commercial tenants from eviction in housing court, and in prosecuting individual and class action lawsuits in federal court against credit reporting agencies and debt collectors under the Fair Credit Reporting Act and the Fair Debt Collection Practices Act. For the past 15 years, I have focused extensively on the problem of tenant blacklisting. As the nature of my practice, the two halves, the housing court half and the federal court half, have literally come together in the tenant blacklisting realm. Tenant blacklisting is a very serious and pervasive problem affecting virtually all residential tenants, regardless of where they live. In a nutshell, blacklisting occurs when a prospective landlord rejects an application from a prospective tenant because the applicant was sued by a previous landlord in a housing court proceeding anywhere in the country, regardless of what the case was about and regardless of who prevailed in the case. Because blacklisting seriously impairs the ability of an individual to obtain residential housing, it is an issue that must be fully understood so that it can be prevented if possible, or at least minimized. Over the past 15 years, my advocacy in this area has taken a variety of forms, including pursuing individual and class action suits against tenant screening bureaus for violation of the Fair Credit Reporting Act based upon inaccurate or incomplete reporting of housing court information about tenants, suing landlords in state Supreme Court to block them from even starting a housing court eviction proceeding that would result in blacklisting. And in that regard, we've now been able to obtain injunctions in about a dozen cases where courts have found that the mere filing of a housing court case creates immediate irreparable harm to a tenant because of blacklisting. And those judges have thus enjoined landlords from suing these tenants in the housing court and instead said to the landlord, you can litigate your eviction claim in the Supreme Court case. Now, obviously, that's not a widespread solution, but it does illustrate the nature and urgency of the problem. I even sued the Office of Court Administration in a Section 1983 action alleging that the Office of Court Administration's issuance and sale of electronic data to the tenant screening companies facilitated the process and resulted in a constitutional violation which chilled the rights of tenants to actually use the housing court. So in my housing court advocacy, I have also endeavored wherever possible to convince landlord lawyers who were threatening to sue my clients in an eviction proceeding to name them only as John Doe or Jane Doe, so as to keep their name out of housing court records altogether, which is really the only way to prevent blacklisting when a case is brought. As a result of those efforts over the past 15 years, tenants, landlords, landlord and tenant lawyers, and housing court judges have become much more attuned to the problem of tenant blacklisting and its causes and effects. Intro 85A represents a well-intentioned effort to solve the problem. However, it does have some significant flaws which should be recognized and addressed, and it must be emphasized that even if it is enacted with or without these flaws, the problem of tenant blacklisting will not disappear, and in some cases will become more problematic. First, the bill essentially creates an administrative violation against a landlord that's enforceable by the Human Rights Commission, where a landlord denies an apartment simply because an applicant was a party to a housing court case. In the real world, however, savvy landlords know that they will have to come up with some other pretextual reason to deny an apartment to avoid liability. And there are many non-illegal reasons a landlord is permitted to use to deny an apartment that hides the fact that it was based on a prior housing court case. Although landlords are required to provide a written adverse action notice if an apartment is denied either in whole or in part because of a credit report, including a tenant screening bureau report, many landlords either ignore this requirement or they're unaware of it. Those landlords who are aware of the obligation and provide an adverse action notice use one that is drafted for them by the tenant screening bureau that they use. These companies provide a full service, including a form adverse action notice, so that the landlord simply has to click a box on their screen and it spits out that notice. But those notices do not identify any specific information in the credit report itself that caused the denial, specifically whether it was a prior housing court case or not. And instead, it tells the applicant to write to the tenant screening bureau to obtain a copy of their report. However, by the time the applicant requests and obtains their report from the tenant screening bureau, that apartment has long been rented to someone else, making the entire process futile. The law is not privately enforceable in the first instance. Without a private right of action, tenants must rely on an already overburdened enforcement agency to provide redress. A landlord who receives a letter, however, from a private attorney threatening suit for illegally denying an apartment based upon a housing court record will be far more effective in overturning a denial of an apartment with the ability to do that. Next, the private right of action must include a provision for the recovery of actual statutory and punitive damages to serve as a deterrent so that landlords who do this repeatedly will pay a lot more than the cost of doing business by engaging in these practices. And it also needs to be recognized that what tenants really want and what they really need, however, is not a lawsuit against a landlord. What they want is an apartment. The bill does not provide that solution. Instead, it forces tenants to repeatedly apply, get denied, and then each time file a complaint with the Human Rights Commission. Nothing in that process makes it even more likely that the tenant will obtain an apartment. And unlike the newly enacted state law, Real Property Law Section 227F, the bill does not contain a rebuttable presumption of illegal discrimination where the landlord obtained or viewed a tenant screening report or housing court records. This provision is critical because it tells landlords who use tenant screening bureaus that they will have a heavier burden in defending against a discrimination complaint if they use these bureaus. When fewer landlords use tenant screening bureaus, the problem of tenant blacklisting dramatically dissipates. Also, many brokers and landlords perform an initial informal and oral screening by simply telling an applicant, don't even bother completing an application if you were sued in a housing court case. The bill as written would not prescribe that conduct, and it should be expanded not only to take this practice into account, but also to expressly include real estate brokers from its prohibitions as opposed to just landlords. I understand that the bill does include agents, but brokers are not expressly included and can be viewed as independent contractors. The bill also does nothing to protect New York City tenants who were sued in the New York City Housing Court when they seek to rent an apartment outside of New York City or New York State. These tenant screening bureaus are national companies, and the housing court records that they sell to landlords are national. So if somebody who was sued in New York City later seeks to rent an apartment anywhere else in the country, that New York City Housing Court case will follow them. I understand there's nothing the City Council or the State of New York can do about that, but it's a reality that this does not end the problem. And also, as a result, both the state law, 227F, and this bill provide a false sense of security to tenants that blacklisting is no longer an issue. It is. In housing court, I've heard judges and landlord lawyers tell me that since the enactment of 227F, there is no longer blacklisting. It's no longer a problem, and that nobody needs to be concerned about it. And I think that's a false sense of security. It needs to be recognized that for the reasons I've stated, particularly because it follows you when you leave New York, that it is still a big problem. A far more comprehensive solution to tenant blacklisting, I believe, is in another bill, Intro 1250, a bill I work closely with Councilmember Callos on, which would require the licensing of tenant screening bureaus by the Department of Consumer Affairs. And it would strictly restrict the type of information about housing court cases they would be permitted to report to landlords. And if they are required to comply with a law like that, it would entirely upend the entire process, because they would actually have to look at these housing court records and not just a computer screen that provides a few word summary of what happened in the case. Now, in 2011, the City Council passed the Tenant Fair Chance Act, which required landlords and brokers to notify applicants in advance if they use a tenant screening bureau, and if so, which one, so that an applicant could go to that bureau, obtain a copy of the report in advance of an application. That was also a well-intentioned bill, but it is largely ignored, and very few landlords either know about it or comply with it, and it doesn't provide a whole lot of assistance in restricting blacklisting. So for all the above reasons, I want to emphasize that I believe that it is a step in the right direction to be taking action of this nature, but I believe that it needs to be supplemented in a number of key ways to make it a much more effective law. Now, with respect to 1603, I believe that there's a lot of dovetailing between the two bills, and in particular, with respect to housing court records used by developers in the lottery process. I've also represented a number of tenants who had been denied housing through the housing lottery system solely because of a prior housing court case. A large percentage of people who are eligible for the lottery have a prior housing court case in their history, whether they deserved it or not. The New York City Housing Court is the largest housing court system in the country, with over 275,000 cases filed there each year. Housing court cases are permitted under the Fair Credit Reporting Act to appear on a credit report for up to 7 years. So when you multiply 7 times 275,000, the chances are that a lottery applicant was previously sued by a landlord for falling behind in their rent. It happens to it happens a lot. It's a very, very common situation where somebody ends up being a month behind and they get sued, and that's all it takes to be blacklisted. Now, the HPD manual, or policy manual, governing the screening process for the housing lottery is particularly of interest to me. It has some very strict guidelines already. However, in my experience, those guidelines are routinely ignored. It's my understanding from litigating in federal court against tenant screening bureaus that developers have essentially outsourced their screening process to these national tenant screening bureaus, who create their own proprietary and entirely opaque credit scoring models, which the developers don't even know about, let alone participate in creating. By doing so, these developers have completely ignored their obligations under HPD policies and regulations, and have instead permitted these national tenant screening bureaus to run their application process, thereby eviscerating the affordable housing lottery process. In a federal class action that I currently have pending against a national tenant screening bureau called CoreLogic, that was filed in the Southern District of New York, my client was denied an apartment in the affordable housing lottery after the developer, Related Management, blindly relied on a screening report prepared by CoreLogic, which referenced a housing court case that had been filed against her several years earlier. That case involved a landlord's claim of non-payment of rent, and it was voluntarily discontinued by the landlord a week after it was filed because the landlord realized the rent had in fact been paid. There was no judgment, there was no eviction, and in fact the case was discontinued by the landlord. Yet several years later, that housing court case appeared on a screening report prepared for Related by CoreLogic, and it was used to deny her an affordable housing lottery apartment. This past December, I conducted a deposition of a corporate representative of Related in that lawsuit, and that deposition confirmed that the HPD policies and procedures for resident selection and occupancy were completely ignored, and that it was Related's policy to, in effect, turn over their screening process to CoreLogic. Major developers like Related, who receive significant financial benefits by participating in the affordable housing lottery, must be strictly regulated in this regard. They must not be permitted to turn over their screening process to national tenant screening bureaus who have no interest in determining the nature and extent of any prior housing court history. Like Intro 85A, 1603 should also be amended to include a private right of action so that persons victimized by the illegal conduct have the ability to directly enforce their rights in court and recover damages and attorney's fees. Thank you for your time.
Thank you very much, Mr. Fishman. Do you have a written statement?
I apologize, I did not have a chance to print it out, but I will
Can
submit
you?
it.
Thank you so much. I appreciate that. Thank you. So we all know that credit score is a big issue. We know that, and for tenants when they are seeking housing. So what do you why you think that credit score is really a big issue for tenants when they are seeking housing? The credit score.
Yeah. Well, I think one thing that has to be understood, the term credit score has many meanings. There are many, many different scores. As I mentioned in the case I have with CoreLogic, they have their own proprietary product called Safe Rent or something. I forget the term they use to describe it. It's made up of a variety of factors. It's sort of like the McDonald's secret sauce. They will not tell you what makes up that score, what factors are used. And the developer told me under oath they don't know what factors go into creating the score that they are then spoon-fed by the tenant screening company. So that's one type of score, one that is developed entirely by a credit bureau. Then there's the national scores such as FICO, which is probably the most well-known. Each of the big three credit bureaus, TransUnion, Equifax, and Experian, have also each developed and implemented their own proprietary scores. And you can pull up all three of your reports on annualcreditreport.com, and each one of those bureaus could be reporting a different score for you because it's all based on a variety of different factors. What the problem with scoring is, though, is the essential problem with all credit scoring, I believe, is that it makes the process into a pass-fail when it turns a subjective process into an objective process. It gives an easy way out to say, sorry, you didn't meet this number, you're out, without looking at, well, why didn't they meet this number? And why is that number so critical? In my case, CoreLogic assigned a score of 505 to my client. The cutoff was 550 to get a conditional approval for the affordable lottery apartment. My client was never told why she got a 505 and what she could do to improve the score. Related was told, but my client was not. There was no policy to inform my client what she could do, because there is a 10-day appeal process where you can appeal the denial, but you're never told why you failed and what, if you were 45 points below the cutoff, what you could do to raise your score. It's a completely opaque process, and it's not in the interest of the powers that be that run these things to tell people what's involved in these scores. So I think scores should not be used at all. I think that they are exclusionary, they're arbitrary, and it doesn't take into account that there's all kinds of subjective reasons. But it does make it faster and cheaper and easier. And that's, I think, what the interest is on the side of the developers.
Is that the question that I was going to ask you? You say that you believe that score should not be used at all. Yes. But now this is not the case. They're still using the score. What other alternative you think that can be used to help the tenants?
Are you talking about in the affordable lottery system,
yes,
or generally?
Both.
Well, I don't see why there cannot be a prohibition against using a score in the affordable lottery system. That's something that's heavily regulated by the city, and certainly the HPD and the City Council can bar the use of scores and instead require more subjective information, as opposed to general, beyond the affordable housing system, in housing generally with private landlords or in credit generally. I don't know that there is a basis to prohibit the use of scoring in that regard. I do think, however, that there can be legislation to require that the creation of the score be more transparent so that people know what they can do to raise their score and what is causing their score to be reduced.
We all know that, when the tenant try to go to housing court with the landlord, that can result of them being placed in the, blacklist. So when you have a constituent, you have a client or a tenant coming to you, anyone can answer this question. You know that, the tenant will have to go to the court with the landlord. And we know that, you know that there's a risk also for the tenant to be in the blacklist. What type of assistance or advice that you provide to the tenant in order for the tenant to be able to handle the situation properly and to prevent the tenant to be in the blacklist?
Thank you for that question. A lot of times we don't have that opportunity because tenants come to us at a time where they've already appeared in court or papers have already been filed. So in the instances where the opportunity to take any preemptive action, we may take measures as trying to negotiate before there's any filing, particularly in the holdover cases before there's any appearance. So I think that is what triggers the appearance on the list. But beyond that, where there is action and there is some indication that the tenant is vindicated either by errors in billing or if there are conditions that give rise to an abatement. We try to draft agreements in a way that reflects that and that cuts off any possibility of a judgment. Just a number of measures to try to mitigate the damage. As was indicated, it's kind of an objective measure that doesn't look at the the facts and circumstances, unfortunately, and that's what we're trying to combat. But where there is like any opportunity to kind of give some context to what occurred, we take measures in that regard, and that kind of happens in the way that we draft agreements.
Thank you very much. I know that Legal Aid Society is providing wonderful services to the people because my office has been working with you guys for many years, providing immigration and legal assistance to people in need. But probably there may be a need to do some more outreach to let the people know about the services that you are providing, and that will give them the knowledge and also the knowledge to come early to inform the Legal Aid Society about the legal situation in terms of housing. And then in that case, you will be able in a position to advise them in advance and probably to prevent them to go to the blacklist. Do you think so?
Well, I think that any opportunity to do outreach and take preventive action, we welcome that. We are present in the housing courts in all of the 5 boroughs. We have offices there where tenants or anyone can ask questions and receive advice from us. And we also work with community-based organizations in all the 5 boroughs, the people who are a lot on the front lines and seeing conditions in the building and bring it to our attention. And that's also part of our outreach efforts. But any ideas that there are to increase those efforts, we certainly welcome them, and we're always exploring those options.
Yes.
I'd just like to add that I think advising tenants to avoid housing court altogether is not a good strategy when we're trying to protect tenant rights and create additional tenant rights and encourage tenants to take action against their landlords, take group actions for repairs, for anything, not to mention all these cases where tenants are unjustly taken to housing court or taken to housing court as like purely a harassment or displacement tactic. And I just wanted to go back to your earlier question and point out one thing about the really unjust dual system of housing between our stabilized or regulated housing and unregulated housing, where a stabilized tenant has a right to renew their lease, can take their landlord to housing court, and feel pretty assured that they're going to be able to remain in their apartment, whereas a tenant in unregulated housing is going to face the repercussions of potentially their landlord not renewing their lease, but then being on the blacklist when they go out to try to search for another apartment. So the risk for a tenant in an unregulated apartment in a small building or a building that was formerly stabilized, the risk is really much greater for them, and they have much less power to assert and protect their own rights.
Yes, sir? You want
Yeah, no, I agree with that there is definitely a huge disparity between the regulated tenants and the unregulated tenants who have no recourse other than perhaps a retaliatory eviction claim, which is not an easy claim to establish. But there's also, it creates an anomaly because in the 2 and 3 family house case, for example, where a landlord says, for whatever reason, I'm not renewing your lease, doesn't need a reason. That tenant then has a choice. Either voluntarily vacate and try and find another place, or go to court and defend the eviction proceeding because there is a state law that allows a housing court judge to stay an eviction for a period of time, up to 6 months, and I believe under the new law, a year, if that tenant meets certain criteria. However, in order to benefit from that state law, you have to first allow yourself to become blacklisted. So it is, a ironic result that if you want to avoid blacklisting, you just move and find someplace else, or maybe go to a shelter. But if you want to take advantage of what the state has afforded, which is to say, yes, we understand that people need time to find another place, their kids are in school, or whatever, you have to be named as a respondent in a holdover proceeding, which has now blacklisted you and made it that much harder to find another place to rent. I don't know the answer to that problem, but it is certainly something that needs to be recognized, that this is a huge number of people in the city who live in such apartments that face this every day.
This is a very tough situation to be, and I think this is a very difficult decision to take also, to be part of the blacklist. Yes. And that is going to put the tenant in more problems. Right. As you said, I think this is a situation that we will have to look into.
You did ask a question a minute ago that I wanted to also answer about other strategies that might be used to help tenants. That's something that I've been focusing on for a very long time in my tenant defense practice, is finding ways to either keep people out of the blacklist altogether by convincing the landlord lawyer to only name them as John Doe or Jane Doe, which only works if they come to me before they've been sued. But I've also developed a mechanism to try and undo the blacklisting problem in settling a housing court case by including a provision in a settlement agreement in which the landlord agrees to substitute my client's name in the caption of the case with John Doe. And then there's also provision that says that the court directs the clerk of the court to remove this person's name from its official record and replace it with John Doe. That document, that settlement agreement, then gets submitted to the judge, and it's now a so-ordered court order, which we then send to the court clerk and say, you now must take this person's name out. And now this is a relatively new process that we've started using in the last few months, so I can't report on how successful it is. But again, my focus is getting the name out. Because once the name is out, either keep it out or get it out. Once that's done, blacklisting is solved. But Without that, it's not.
Thank you very much. We know that protecting people's identity is a very big issue everywhere in New York City and everywhere in the world. And people may be in a very difficult situation because of mistaken identity. So in case of housing situation, did you ever hear cases of people being in the blacklist because of mistaken
Absolutely.
identity? And what you suggest, what you have,
Well,
what you are able to do, what is
Well, first of all, if you think of the context of identity theft, and I have also represented a lot of identity theft victims who were, either their identity was stolen or in a more benign situation, the credit bureau merged their files with somebody else. Keep in mind that in regular credit bureau reporting, big three, who are reporting mostly trade line information, there are 2 extra layers of protection to ensure that you have the right person. There's a date of birth and a social security number, which are tied to every credit transaction. And so when somebody's, when a trade line, a credit card appears on somebody's credit report that's not theirs, either because it was merged from somebody else or somebody stole their identity, there is a way to address it with social security number and date of birth at a minimum. However, with housing records, neither of those identifiers exist. There is no social security number attached to a housing court record, and there's no date of birth. So all you have is name and address. You have very large buildings in New York with hundreds of people with the exact same address, taking away the apartment number for a moment. The chances of somebody with a common name having the same name as somebody else living in their building is substantial. And so yes, it is much more likely that somebody could be denied an apartment because of somebody else's housing court case, because there is a complete absence of those identifiers in creating the report in the first place.
And thank you very much. So probably this is a question for Legal Aid Society. Is there anything that you have been able to do to help people improve their credit scores? Or anything you have available to help them? Because the credit scores, is really a problem for those who are seeking housing.
So my work in the Legal Aid Society is mostly around housing. We do have a unit that does assist consumers with cleaning up their credit and dealing with discrepancies. I think they would probably be able to speak more to that process, but we definitely have attorneys and staff that do work to help people with that.
Okay, thank you very much. My last question, are you aware of any other practice evaluation used by other jurisdictions in terms of qualifying people for housing, like in other state,
Yes.
other than credit score?
Are you talking about to prevent the blacklisting problem or to address
Yes.
it? Well, I know that in California, they passed a law barring the use completely of housing court records in evaluating tenants, and that law was thrown out on constitutional grounds. They passed a subsequent law that prohibits or actually seals housing court records for the first 90 days because practice shows that an overwhelming majority of these cases get resolved rather quickly. And so if they're sealed during the first 90 days, then they're not accessible to the tenant screening companies. Now, that is something that I've looked at as to whether that would work in New York, and I don't believe it would, for the reason that because we have the largest housing court system in the country, the volume is such that the company that actually gets the data directly from the courthouse is months behind already in keeping up with the volume. So even if there was a 90-day freeze, if they don't look at that case for 6 months, the case will be unfrozen by then. So I don't think that works in New York. Right now, there is only one company in New York that is obtaining the housing court records, housing court information, and then selling it to all these other companies, and that's Lexus. And the process that they use is they send people into the courthouse clerk's offices with a laptop, and they sit at the public access computer, and they simply take down the information right off the screen, put it in their computer, and then upload it to Lexis. And they do that every single day that the court is in session. However, what I've discovered is that there's a huge backlog because they simply can't keep up with the volume. So there isn't a lot of currency in the information. So if a case gets dismissed or discontinued, they don't know about it for 6 or 9 months. And if they report that information, for example, if the case was filed and it's an ongoing case, but it was actually dismissed or discontinued, then the tenant screening company is not getting fully current information about that case, and then the landlord who's reviewing that applicant is also not getting current information. And I can't say that I feel badly for the company, for a company like Lexis who can't find a way to get information, since that's their job. They're in the information business. But that's the reality because we are the largest housing court in the country.
Okay, with this, thank you so very much, all of you, and have a wonderful day. Thank you so much.
Thank you.
Thank you.